What I notice is the first word, Congress. Congress shall make no law. And when you compare this to the English Bills of Rights, the English Bills of Rights restrict the power of the king. And the American Bill of Rights, somewhat ironically, restricts the power of Congress. It's ironic because what we've done is create a Republican form of government where we vest Congress with enormous authority, but we're saying that Congress is the most likely entity to violate our liberties. On the one hand, we have enormous confidence in the power of Congress to represent the will of the people, but on the other, we are looking at Congress as a potential abuser of liberty. If you look at the verbs and you compare it, say, to the Maryland Constitution, the Maryland Constitution says the House of Delegates ought not, should not. In this, it says shall. And if you look at the verb throughout the Bill of Rights, or in the Constitution itself, there is an absolute prohibition. It shall not do this. The First Amendment reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people peacefully to assemble and to petition the government for a redress of grievances. Prioritization is very important here. Certainly on the minds of many of the founders, they did not want an establishment of religion along the lines of the National Church of Great Britain or the national churches of Spain or France. So they did not want a national church, although at the same time they recognized the rights of the states to have an establishment of religion on the state level if they so chose. More importantly, however, they were very concerned with the free exercise of religion, that is, for people to believe what they wanted to believe. The second theme, as I see it, is this theme of Republican government. You want the people to have the freedom to assemble and speak, to publish their ideas in the press, and to petition government for redress of grievances. That is what the revolution was all about. The Fifth Amendment of the Bill of Rights states, no person shall be held to answer for a capital or otherwise infamous crime unless on the presentment or indictment of a grand jury, except in cases arising in the land and naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor to be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. There's a tremendous amount of litigation that is represented in the Fifth Amendment. The double jeopardy clause, something we're all familiar with, which is if you've been tried and found innocent, you cannot be brought on the same case before another court, or you cannot be compelled to be a witness against yourself in self-incrimination. The due process clause directly relates to an English protection. Article 4 of the English Petition of Right stated that no man should be put out of his land or tenements, nor taken, nor imprisoned, nor disinherited, nor put to death without being brought to answer by due process of law. And so the due process clause is a direct descendant of that, as are many other provisions in the Bill of Rights. Following the Civil War, African-American citizens were not given due process rights by the various states, which resulted in the 14th Amendment being passed, which would protect their rights, their liberties, as citizens of the United States against the abuse of the state.